Welcome to the latest Evershed Sutherland Legal Insights podcast.
Hello, I'm Naima Chowdhury, a partner in our employment team. I'm very pleased to be joined today by my colleague Suzanne Caveney, who's an employment partner, and Charlotte Cartwright, who's a pensions partner. 2025 marks 50 years since the coming into force of the original sex discrimination and equal pay laws in the UK, with the anniversary of when the laws came into force at the end of December. It's also the anniversary of the Equal Opportunities Commission being established 50 years ago, its functions having since been absorbed by the new Equality and Human Rights Commission, as well as this year being the 60th anniversary of the employment tribunals being established. So we thought we'd take a moment to reflect on how far the law has come and where it is expected to go next. We're going to have a look at some of the most significant events and cases and what the situation was like prior to the legislation coming into force. Well, in 1968, there was a strike at Ford's Dagenham plant led by women sewing machinists, which became a landmark moment in British labour history and gender equality. Sparked by the reclassification of their skilled work as unskilled, the machinists demanded fair grading and equal pay, ultimately halting car production and drawing national attention. The TUC and the newly formed National Joint Action Campaign Committee for Women's Equal Rights supported the strike, culminating in a demonstration in Trafalgar Square and influencing the passage of the Equal Pay Act in 1970. Politically, figures like Barbara Castle played a pivotal role in brokering a deal that ended the strike and laid the groundwork for the legislative reform. The reform also aligned with the UK's preparations for entry into the EEC, which mandated equal pay under Article 119 of the Treaty of Rome. So the legislation that we ended up with was the Sex Discrimination Act in 1975, which emerged from a growing recognition in the early 1970s and the Equal Pay Act in 1970, whilst groundbreaking was insufficient to tackle broader gender equalities in the workplace and society. The Act was designed to make it unlawful to discriminate on the grounds of sex or marital status in employment, education, and access to goods and services. It also established the Equal Opportunities Commission to enforce the Act and monitor progress. Importantly, the Act came into force on the 29th of December 1975, alongside the full implementation of the Equal Pay Act, marking a coordinated effort to advance gender equality. So following the legislation coming into force 50 years ago, there's been a series of events and cases that shaped today's protections. So, Suzanne, turning to you first, can you highlight some of those developments?
Yes, of course. Thanks, Naima. There are so many, but if we think about some of the highlights where we can see a clear thread between where we were then and where we are now, I think absolutely the first was the industrial action in Dagenham that you've mentioned, but that then sparked a wave of industrial disputes demanding equal pay throughout the 1970s, because many employers, despite the Equal Pay Act itself, were very slow to implement equal pay. One of those industrial disputes was Tricor Fulberth, which was a US-owned company in Brentford, which manufactured windscreen wipers. Now, that factory employed a large number of women, primarily in assembly line roles, while the men held more technical or supervisory positions. Now, those women were being paid significantly less, as was very common back then, than their male counterparts for doing what was equivalent work. So around 400 women walked out in May 1976, supported by their union, the TGWU. And that strike lasted 21 weeks, making it still one of the longest industrial disputes led by women in the UK. Then we had the case of the Commission against the United Kingdom in 1982, which was a case brought by the European Commission against the UK. suggesting that the UK's implementation of the Equal Pay Directive was in fact inadequate. And the court agreed with that and held that the United Kingdom had failed to fulfil its obligations by not ensuring that women could claim equal pay for work of equal value. Now, that was because the Equal Pay Act back in 1970, as originally enacted, only provided for equal pay where men and women were engaged in like work or work rated as equivalent under a job evaluation scheme. So it didn't allow women to claim equal pay for work of equal value unless the employer consented to a comparative evaluation. And the court found that that was inconsistent with the principle of equal pay. So that decision then led to the 1983 Equal Pay Amendment Regulations, which introduced the right to claim equal pay for work of equal value under UK law. And even now we see that many of the equal pay litigation is in the sphere of equal value. So very, very significant decision. One of the first cases in that line was Hayward and Camel Laird in 1984. Miss Hayward was a canteen worker whose work was found by the Employment Tribunal to be of equal value to that of her male comparators who were employed as shipbuilding craftsmen. Now, despite this finding, her employer argued that Miss Hayward's contract, if we considered it as a whole, was actually more favourable than those of her male comparators. Because whilst her basic pay and overtime rates were lower, she received superior benefits such as sick pay, holiday pay, and paid meal breaks. Now, this case ultimately reached the House of Lords, as it was then, which addressed whether equal pay claims should focus on a comparison of individual terms of the contract, or whether indeed it is possible to compare the value of the contract as a whole. And ultimately, the House of Lords rejected that argument and said that contracts should not be assessed as a whole, but rather that each term of a woman's contract should be compared with the corresponding term in her comparator's contract. And if any term is less favourable, it must be then modified to ensure equality. This approach prevents employers from offsetting lower pay with superior benefits in other areas, which might then mask some systemic inequalities. That then also laid the foundation for what we saw was a raft of equal pay litigation beginning in the early 2000s with the local authority equal pay litigation following the implementation of single status, right through to the current day where we're seeing mass equal pay claims in other sectors. Very significant decisions.
Thank you very much for that, Suzanne. So in parallel to these developments from the 70s to the early 2000s, changes were also taking place around gender equality in occupational pensions. Charlotte, was there a landmark ruling in 1990 that you can describe?
Yes, absolutely. So there was a landmark case in 1990 before which pensions were often seen as a bit of a fringe benefit for these purposes, so not subject to the equal pay rules. At that time, many occupational pension schemes in the UK had different retirement ages for men, often age 65, and for women, which were typically age 60, and that resulted clearly in unequal pension benefits. In the Barber case in 1990, Mr. Barber and the fact pattern was made redundant at the age of 52 and he was denied an immediate early retirement pension under the scheme rules. But you can compare that to a female employee in the same circumstances who would have got such a pension. Now, the ECJ ruled in favour of Mr. Barber. It held that occupational pensions are pay under Article 119 of the Treaty of Rome, and so men and women must receive equal pension benefits if they're doing the same or equal equivalent work. Now, that decision really brought occupational pensions within the scope of the equal pay legislation, just reinforcing that principle of equal pay for equal value.
A very significant decision. So turning to the present day, what recent cases or developments are continuing to influence and redefine the sex discrimination landscape? Charlotte, is there a case that you want to mention?
Yeah, sure. So in the pension space, the line of cases is really the Lloyd's judgments that confirm that schemes do need to correct for benefit inequalities arising from differences in how GMP are calculated for men and women. So GMP benefits are those benefits that members may have built up in their pension scheme a while ago because the scheme was contracted out of the state scheme. And this relates to equalising those benefits, for the effects of those benefits accrued between 1990 and 1997. And a number of schemes are still working through their projects of what that actually looks like and means for their scheme.
Thanks, Charlotte. Suzanne, what about you? What are your thoughts?
There are almost too many to mention, Naima, but if we think about some recent case law developments that I think are then going to continue for some time to come, I think we are talking about those cases we've seen in the context of the protection of philosophical belief as a protected characteristic under the Equality Act as a starting point. Now, the key case here was a case called Forstater. Now, Miss Forstater claimed that she was discriminated against and lost her job after expressing gender critical views, specifically her view that biological sex is immutable and should not be conflated with gender identity. Now, she brought an employment tribunal claim, and back in 2019, the first instance tribunal held that her views were not protected under the Equality Act as a philosophical belief. But in contrast, on appeal, the Employment Appeal Tribunal concluded that those beliefs were indeed protected as a philosophical belief and emphasised that those beliefs, even if they might be offensive to others, must be tolerated in a pluralistic society. They also noted that the contrasting belief in gender identity, which asserts that gender might differ from biological sex, are similarly protected under the same provision, so equal protection in that respect. Now, in a full merits hearing back in July 2022, it was found that Ms. Forstater had in fact been directly discriminated against because of those beliefs. So her claims for direct belief discrimination and victimisation therefore succeeded. And we've seen following that case a series of other first instance decisions based on philosophical belief. So we're seeing a real increase in that being the basis of discrimination claims. We also have then had relatively recently the case of For Women Scotland in April of this year, 2025. And that was a case in which a group called For Women Scotland challenged the Scottish Government's guidance in relation to public boards, access to public boards. And that guidance said that the definition of woman for these purposes included trans women who were in possession of a gender recognition certificate. This case went all the way through to the Supreme Court, who ruled that actually the term sex for those purposes refers to biological sex, not sex acquired through gender, even where there is a gender recognition certificate. So what that does is it means that sex assigned at birth remains legal sex, even where an individual might have gone through the process of obtaining that gender recognition certificate. So a very significant decision. Now, what the Supreme Court did do in its judgment, however, was seek to clarify that whilst trans individuals retain protection under the Gender Recognition Act and indeed the Equality Act, they're not included in the definition of woman under that legislation. Naima, do you have any thoughts around what might be coming next?
So yeah, before we talk about something that's coming next, I do also want to mention a quite significant piece of legislation that came in about a year ago. So we saw reforms to the harassment legislation back in October 2024, where for the first time there was a proactive duty on employers to take reasonable steps to prevent sexual harassment in the workplace. And that was a very significant change in shift from employers having to be more proactive, less reactive, to preventative obligations. So the obligation was to take reasonable steps even before any complaint had been received of sexual harassment. And whilst the legislation doesn't give employees a right to bring a claim if the employer doesn't take reasonable steps, it does mean, though, that if a successful claim is brought, that employers can face increased liability, including an uplift of up to 25% in any tribunal compensation, which is, you know, a significant amount, given the fact there's actually no cap on the amount of compensation that's payable in any event. In terms of looking ahead, we've got the Equality Law Call for Evidence. So the government is seeking views on strengthening the equality law, including extending equal pay rights, improving enforcement, and addressing outsourcing. And they're also talking about introducing mandatory ethnicity and disability pay gap reporting. So the forthcoming Equality, Race and Disability Bill will require large employers to report on ethnicity and disability pay gaps using a framework similar to gender pay gap reporting. But I think there's also changes on the horizon, Suzanne, in relation to equality action plans and extending equal pay legislation. Do you want to talk a little bit about that?
Yes, absolutely. It's a very busy time for those that are keeping an eye on changes in the equality sphere generally, but absolutely specifically, we're expecting consultations to land relatively soon in relation to regulations that will require large employers to develop and publish an equality action plan, showing the steps that they are taking in relation to gender equality, but specifically any measures that they're taking to address an existing gender pay gap and supporting employees going through the menopause, and then to publish prescribed information relating to that plan. So we are still waiting for some detail, but we do expect that in principle, those equality action plans will be coming into force in the not too distant future. We do also expect, building on that equality and equal pay piece and what's coming next, that we will see an extension of equal pay rights to cover race and disability, introducing measures in relation to that to bring it more into line with what we're seeing in relation to equal pay based on sex. So a lot of change happening there.
And obviously, we're going to have some more reforms in relation to sexual harassment, where the duty to take reasonable steps will become all reasonable steps, and third-party harassment liability is going to be introduced for all forms, so for all protected characteristics, not just sex. Okay, so I just want to finish with sharing some examples of how we've been helping clients navigate and respond to discrimination issues in practice. Suzanne, do you want to talk about a couple?
Yes, absolutely. So again, starting in the equal pay space, our specialist lawyers here have been very busy indeed. We have seen a rise in grievances and individual equal pay litigation, which is always very complex. But coming with that is then a realization, I think, by a lot of clients and employers that they want to understand what their equal pay risk looks like. So really unpacking what might be sitting behind a gender pay gap, looking at specific equal pay risk through legally privileged audits, and working with clients then to implement action plans to try and address any of those risks if they indeed do exist. And sticking with pay for a moment, we also have the implementation of the European Pay Transparency Directive, which we haven't mentioned, but nonetheless is significant for any employer with a footprint in Europe. So we've been supporting a number of clients in relation to understanding what those legal requirements are as they continue to evolve in the various different jurisdictions, and help supporting them in planning and implementing measures to identify and analyse any pay disparities that might exist, communication approaches when we get there, and other issues that are very significant and sometimes forgotten about, such as confidentiality and privilege matters, data privacy, and manager training. So a lot going on in the pay space. From a harassment perspective, we're also supporting clients with training and risk assessing, where the risk of harassment might arise, so that they can mitigate those risks and demonstrate that they are actually complying with that proactive duty that you mentioned, Naima.
Thank you. So if somebody was asking me to predict what's going to come next, I would definitely be saying more litigation arising from the extension of equal pay rights to cover race and disability, and probably more enforcement that we'll see as well. But what's your one prediction, Suzanne, in terms of what you think is coming next?
It's difficult because there is so much going on, but aside from that trend that you've already mentioned, Naima, I think we'll see, with the change in the harassment requirements, more findings of liability for employers that fail to protect their employees against harassment. So I think we will see a huge increase in challenges there, and unfortunately, a lot of employers might well fall on the wrong side of the line.
Thank you. Thanks to Suzanne, to you and to Charlotte for a really interesting discussion. Speaker details are in the show notes and our website. Please also check out the show notes for links to our website and other relevant materials, including our interactive site tracking the UK employment law changes. Thank you for joining today.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.